welcome everyone. Sorry to keep you waiting just a couple of minutes today. So our privilege to have three partners from Mills Oakley, which is a leading Australian law firm that you may have seen around the country. They've been, I think, one of the fastest growing law firms actually in Australia, which says a little bit about their service and professionalism. But I'm Rob Douglas, Executive Director of Australian Owner Manager, and today, in terms of the webinar series, we're focusing on some of the legal issues around the current situation with COVID-19. So we've got Pablo Fernandez, who's a partner with Mills Oakley. He's a specialist around leases, commercial property developments, those types of things, and so he's going to talk a little bit around the current leasing situation. Then we've also got Warren Scott, who's a partner in the commercial area. He's going to look at some of the key contract clauses that you need to be aware of and be thinking about in the current environment. And then we've got Tony Laylor, who's also a partner in the corporate area, and he's going to look a little bit more around probably a bit of a recap maybe on some of the staff type issues, and then also looking at some of the directors' duties and responsibilities and things that you need to be aware of there. So I'm just going to kick over now to Pablo and let him run, but I would say if any of you have any specific questions along the way, just use the Q&A function within the webinar and we'll endeavour to address those as we proceed. But over to you, Pablo.
Thank you. Hi everyone, I hope your day's gone off to a good start. Look, I'm told that the majority of the listeners out there are probably largely tenant-based, so I'll focus and try and give you more insight from a tenant perspective rather than a landlord. So I guess at this stage, where we're at, it's probably important to start with where we're at in terms of the law and what changes there have been to the law to assist parties, whether they be landlords, tenants, banks, whatever, to deal with the ramifications of COVID in how it touches and concerns leases. So at the outset, as at today's date, there is nothing set in stone for leases in particular in terms of legislation. The closest that we probably have gotten is that in New South Wales, an act was passed to give the minister powers to amend certain legislation with respect to leases. And this is around the country. That's the closest we've gotten, is that the minister in New South Wales now has the power to make certain regulations with respect to leases. But aside from that, there actually is nothing set in stone as yet. So what does that mean? That means that we have to fall back for the time being on the provisions of the leases. So in terms of where that's at, so as I'm sure you know, and what's probably got the majority of you the most concern, is that the rent is still due and payable in the way that the leases require it to be. Usually that would be on the first of the month, and the rents, on that basis were due and payable yesterday, and all those leases remain on foot. Payment of rent is an essential term, and the risk that parties are currently running if they're not paying that rent is that landlords can terminate leases. Now, that being said, I'm sure you're all aware of it, that the Prime Minister came out probably about a week ago now to say that there would be a moratorium on the termination of leases in the next 6 month period. As I said earlier, that hasn't translated across to legislation as yet. So while that's been stated, it isn't in legislation yet, and I imagine perhaps that when the legislation gets enforced, or rather gets enacted, that it will be retrospective and it'll be backdated. So again, that's just a guess because we don't know yet. So of course that results in a general uneasiness between landlords, tenants, banks, And the government's position at this stage is, besides the moratorium, which they've said will apply in cases where tenants, and Scott Morrison's words from memory, were severely financially distressed as a consequence of COVID-19. Only those tenants will be protected, as far as I'm aware. So, yes, of course, there is uneasiness between landlords and tenants. Landlords are concerned that the Prime Minister's statements give rise to tenants just to not pay their rent for the next 6 months. I don't think that it goes that far. I think that that would be, certainly from a tenant's perspective, not a wise move to just consider that you can completely ignore your lease obligations to pay rent for the next 6 months. I don't think that that's the intention. And of course, from a tenant side, tenants would be very distressed at the fact that nothing's been passed yet, and that they're left in limbo. And landlords probably, I've acted for a lot of landlords, a lot of major landlords, and their view is that they've been holding out on more to come from the government, and now they're starting to move towards speaking with their tenants and trying to get information and so on and so forth, to potentially come to deals with those tenants. Right now, what we have is what we're told is that there will be a set of model rules developed that should influence and drive landlord and tenant communications between one another, and how they might seek to come to a deal, so to speak, as to how their leases are going to work for the next 3 to 6 months. I mean, Scott Morrison's saying 6 months. Again, it's difficult to know without any actual legislation from governments. What I can tell you is that the legislation, once it gets enacted, and I'm not sure where you're all joining from around the country, but it will be different state by state. And so far, the positions have been fairly consistent in terms of the directives around movement and so on, and the closures of stores and so on. It's been fairly consistent around the country. I imagine, and I can only imagine, that when it comes to rental relief, rental abatements, and the like, I don't know that it's going to be the same around the country. I just, I can't see the states and territories all agreeing to the same thing in that regard. So I can't say that it's going to be the same in that regard. Yes, so where we are is that there are certain shops that aren't allowed to open. Now, I'm sure, I don't know how many of you operate those kinds of shops, but I'll just bring up a separate document that I have to sort of run you through the types of stores that are currently prohibited. So at the moment, what we know is that there are certain, and I'm only speaking about Victoria here, but the situation is very similar in New South Wales. So in Victoria, the prohibited shops, if you can call it that, prohibited facilities is the word that is used, is pubs, bars, clubs, nightclubs, hotels, other recreation facilities like gyms, pools, health clubs, facilities used for mini golf, paintball, lawn bowling, swimming, water skiing, go-kart tracks, rifle range or equestrian centres, tennis centres, or basketball centres, unless only one court is in use and no communal equipment used. Indoor and personal training facilities are required to be closed. Community centres and community halls, libraries, galleries, museums, youth centres, play centres or playgrounds, skate parks, and outdoor communal gym equipment. Likewise, entertainment facilities have been shut down, although that's been the case for the past few weeks. Places of worship and restricted retail facilities. So not all retail shops are closed, but the following will be beauty and personal eye care facilities, auction houses, market stalls, and markets. So with markets, I'm talking about clothes, not food. So market stalls can still operate for takeaway food, and markets for clothing and the like can be open if there is less than one person for every 4 square meters. Now, the general consensus is that takeaway is still okay, and food and supermarkets and the like can remain open. So even though that's the case, the trouble with the leasing landscape, as I'm sure you all can appreciate, is that we don't have, even though those shops are required to be closed, as to whether or not those tenants are required to continue to pay rent, the answer is it all comes down to what the lease says. And the leases at present, the ones that I mean, generally speaking, leases will require tenants to continue to pay rent no matter what. And typically speaking, tenants take on their leasing obligations, and they take on the premises as it is most often. It's not always the case. It's not a blanket rule, but it's most often the case that they do take premises as they are, which means that they take on the risk of those premises. So what does that actually mean for you guys? It means that right now the position is that you've taken on the risk, and you what you get in return for the payment of your money is the right to occupy that particular premises, and that in itself, and you're required to pay the rent. So that unless you have a specific provision that allows you to not pay rent under your lease, you actually do have the obligation to pay that rent. As I was saying, the government is currently working on addressing this, but they've largely left it back on landlords and tenants to work it out between themselves for the time being. So that creates a bit of a disconnect, because landlords don't want to go too soon and make deals, and make a deal, and for that deal to then be undone. And meanwhile, the landlords and the tenants have actually taken on quite a bit of a cost and the like to actually get those deals documented. So yeah, so the lay of the land at the moment is that we really don't have many answers, but we have some general guidance notes from the government, that there are general principles that they want people to, well, landlords and tenants to work through, and the justification for landlords is that what they're saying is that the banks will, well, or rather the landlords will also get to benefit from the from the policies of government, and from any help that the government introduces. Whereas if they don't play ball, so to speak, if they don't take on these principles and work with their tenants, and they don't get the benefit of that. And what I'm talking about there is things like banks. So you may have seen the recent announcement that banks have told their business customers, their landlords, that basically if they're providing relief to their tenants, that the bank will work with them so that they don't have to pay their repayments to the bank for that set period. I think it's, at the moment, it's 6 months is what they're saying. But of course, the problem with that for landlords is that they're accruing interest on all that money in the meantime. So it's kind of it's a very complicated situation, because no matter how you cut it up, there's always, it's never really fair for everyone. It's not fair. Which is probably the part of the reason why the government just can't come to actually enacting legislation here, because it's too complicated, and no matter how one thinks about it, someone gets affected unfairly in every situation. If they just introduce a waiver, like a relief or something for tenants, then that is unfairly prejudicing a lot of landlords around the country. So at the moment, I'm not certain that the government is actually going to introduce any kind of permanent relief as such. I think that would probably be a stretch, because it would undermine like the rights and entitlements of a landlord. So at the moment, I mean, the principles, the important ones that I've got in front of me here, are that they want us to work through is that it's a short-term temporary moratorium on eviction for non-payment of rent to be applied across commercial tenancies, and that includes retail. impacted by severe rental distress due to coronavirus. Number 2, tenants and landlords are encouraged to agree on rent relief or temporary amendments to the lease. Reduction or waiver of rental payment for a defined period for impacted tenants. The ability for tenants to terminate leases and or seek mediation or conciliation on the grounds of financial distress. Commercial property owners should ensure that any benefits received in respect to their properties should also benefit their tenants in proportion to the economic impact caused by coronavirus. 6, landlords and tenants not significantly affected by coronavirus are expected to honour their lease and rental agreements. And 7, cost sharing of or deferral of losses between landlords and tenants with Commonwealth, state and territory governments, local government and financial institutions to consider mechanisms to provide assistance. So as you can see there, it's all very much you guys work it out. Here's some guiding principles that might help you. But it's like I said, I think I'm not sure that we're going to get to any kind of formal waiver or anything like that. I think if anything's going to be enshrined in law, it'll probably be these principles of how tenants and landlords should work together to actually try and achieve an outcome. There's been some of my clients have been considering other alternatives, such as, you know, what if we just provide a rental deferral and for a set period, and we extend the, you know, or if it's an abatement, we extend the lease by a certain amount of time at the tail end, and, you know, and that sort of thing might work. If your tenants out there, you know, that might be something you put to your landlords now. I mean, if you are experiencing financial hardship, that might be something that, you know, a way to, you know, a deal that you could come to perhaps, you know, and like I said, you know, if you're going to have a 3-month rental abatement now on account, or 6 months or whatever it might be, on account of coronavirus implications and severe hardship, perhaps then, you know, the offer to the landlord would be, okay, well, if you do this for us, we'll extend our lease by 3 months at the end of the term, or 6 months or whatever it may be. And, you know, and the idea behind that is that the landlord gets the benefit of a longer lease term, you know, and that might be enough for some landlords. It might not. It's like I said, it's the government's very much taking the view at the moment of putting it back in the hands of landlords and tenants to just simply and I think these were even Scotty's words, work it out, which is, you know, not overly helpful, but I think it's the reality of how complicated this is to legislate on. And, you know, you could even see it in Scott Morrison's face that he looked troubled by the conversation of tenancy legislation. And, you know, I think it took 2 extra days from what it was initially anticipated to even give us a briefing on it. And it is complicated. It's very complicated. You might find as tenants that if you apply to your landlords, that they will ask you to give them, you know, details of your P&L for the last 3 years, details of whether you've spoken to your insurer about business interruption insurance and whether you have any coverage under that. The answer to that from my tenants or lease has largely been no. You know, that they will ask you if you're willing potentially to put up further security, or, you know, or an extended term. So, you know, I think that landlords actually do recognise that it's in their interest to keep their tenants. So I don't think that we'll see, you know, landlords being overly aggressive. I wouldn't have thought, particularly to smaller operators. I don't think we'll see them being overly aggressive. I had a landlord client that a week ago, you know, before a lot of this stuff came out, a week ago, rang me and asked me to do a letter to their retailers at the bottom of a commercial office, and no questions asked, has given them all a 3-month holiday from rent. And that was, in my mind, unbelievably generous. And, you know, and it was pretty much a no questions asked. It was just, we are going to give you guys some rent relief for the next 3 months, and we'll see how we go after that. So, you know, it's not all doom and glooms. There are some landlords out there that are behaving in that kind of way, and that are being conciliatory. Likewise, I'm sure there are other landlords that don't have that kind of capacity to be able to do that. So, yes, unfortunately, we're at a position now where it is incredibly difficult from a legislative point of view, and I don't think we're going to see any kind of rent relief that is legislated unless that's coupled with something else. So, yeah.
Pablo, that's really helpful in terms of setting the scene and just helping everyone to understand and, you know, getting your thoughts and reflections. One of the questions that we've had come through is, you know, are we just talking property here, or, you know, is there anything out there in relation to, say, plant and equipment or those type of leases in this regard that you're aware of?
Yeah, look, that I think is probably more of a question for Warren, if I'm not mistaken, Warren. Or Tony, maybe.
Well, maybe we'll come back to that then. I'll just leave it there and come back to that. Is there anyone else out there? Like the other question that did come through was just, you know, is there any way to avoid a breach without when you don't pay your rent? Which is probably self-explanatory that there's probably not any way to avoid a breach by not paying your rent. But I'm not sure if you've got anything else to add in that regard.
Probably not is the answer to that. It would be surprising to see any lease that, you know, that didn't make payment of rent in a fundamental term of the lease. That being said, you know, in the past, I've been pretty crafty with the way I've drafted leases for tenants before, and, you know, I've drafted before to say that, and until they've given a notice that it's not a default until landlord's given a notice. So if you miss your rental date in that particular drafting that I've done in the past, it's not an actual immediate default until they've actually given you notice in 14 days to comply. You're not actually in default. But that is very rare to get that across the line with landlords. So no, there's no way that you can just be not in breach. Look, there are some leases out there that provide in the damage and destruction clause. The damage and destruction clause is the clause that is typically there to say that if the building is destroyed or damaged, that rental isn't payable. There are some damage and destruction clauses out there that are a lot broader than that sometimes you could potentially make an argument that your rent isn't actually due because you're not entitled to occupy your premises. Now that is very much I'm not going to say it would be difficult to argue it, but in some cases it would be arguable if your lease was drafted in a particular way that said the inability to occupy in and of itself was an event that meant rent was not payable anymore. I have seen that before, and, you know, and certainly drafted that way before, that the inability to occupy is also a deemed event that would stop rental being payable. That might be in some cases, in some leases that may be the case. And then it would be, well, is it that you can't occupy the premises, or is it that you're not allowed to trade from it? Because they're two different things. So like I said before, it may be an avenue to go down, but in present circumstances, I would suggest that you actually are entitled to occupy it. You just can't run your business from it, which are two different things. So say, for instance, if you're a tenant out there listening and you have an obligation if there's an obligation in the lease on your landlord, to ensure that all licenses and permits are in place for you to be able to trade, and whether, for instance, warranted, giving you advice, or rather giving you a warranty that the premises are fit for use, then you've probably got a better case to argue. That they're unusual, those types of clauses, but they do exist, where a landlord gives a warranty that about the permitted use. There you might have a better case to argue. And, you know, a landlord might have to listen a bit more attentively if that was the case.
Thanks, Pablo. I might just, I'm just in the interest of time, there's one other question, but I might just deal with that at the end. So I might just kick over to you, Warren, just in the interest of time, and you can start to talk us through some of the other contractual types of clauses that we need to be mindful of in these conditions from a general perspective rather than just leasing.
Yes, thank you. My vision is actually a little bit delayed. Hopefully my audio is running on time. So can you hear me?
Yeah, we can hear you, Warren. Sorry, Warren, you're just on mute there. There you go. Start again.
Yeah. So I'm not sure where I picked up that off. But yeah, so what I want to talk about is some of the relevant issues from a more general contractual perspective, not just real property. And the real questions at the moment that people have at the moment is, do they have to pay or not pay? Can there be a delay or suspension of rights? Or is there an ability to actually terminate contracts? Sometimes people want them to be on foot and sometimes they will want to terminate them. Most relevant to that, following on from what Pablo said, the most important thing is what's actually written in your contracts. So the key contractual provisions will be different on each occasion. So you need to go back and read them. What I'd like to do is give a few pointers to people of the kind of things to look out for when you are reading your contracts. So one of the very first things that you want to look out for is time of the essence in respect of your contract? Does it need to work to a particular time frame? For example, in building and construction contracts, time is typically of the essence in respect of those contracts, and there'll be damages payable in respect of delays. So absent other provisions that you might be able to rely on, people are in a situation of missing deadlines as a result of this particular issue. And also, what some people are thinking about is material adverse change clauses that are also built into certain transactional documents. So for example, mergers and acquisitions, other key financing arrangements. People typically, to manage the risks between signing and completion, there will be provisions in those documents which talk about what happens if there's a material adverse change or a material adverse effect. And those provisions need to be looked at very carefully to determine, one, has there been a material adverse event or a material adverse effect? The actual COVID-19 itself, I'll talk a little bit more about when I talk about the force majeure clauses, but it may not be that itself, but it may very well be that the effect is a material adverse effect, which can be relied on by parties who have a material adverse change clause within their contract. Force majeure is a relevant concept that lots of people are talking about. Force majeure does not apply just by operation of law within Australia. So you need to have a force majeure provision in your contract. Force majeure provision is where effectively you say it's an act of God, something that's outside of the control of the parties. If that was to happen, what would be the relevant outcome as a result of that? When people draft their force majeure clauses, they can be drafted in a range of different ways to write into the agreement what is the relevant force majeure events. Again, there's no one set of rules that says if you write the word force majeure, it covers particular events. So the people need to look carefully at those categories as to what's drafted in and also what happens. Is there to be a suspension for a period of time, and then is there to be an ultimate termination, and what happens during that period of suspension? So the first one is, if you do have a force majeure clause in your contract, what kind of things are covered in it? Acts of God, natural disasters, industrial action, sabotage, a range of different matters that could be included within your contract. And is it an inclusive definition or is it an exclusive definition? If it's an inclusive definition, for example, all kinds of things that are outside of the party's control, including acts of God, including terrorism, including, you're much more likely to be covered by a COVID-19 related event or effect. Whereas if it's drafted as an exclusive definition, is force majeure only includes storm and tempest and these kinds of things. It may very well be that you sit outside COVID-19 and its effects, giving rise to triggering a force majeure provision. But just as a general comment, most force majeure provisions will include an act of God, and there's a relevant case which is Commissioner of Railways and Stewart, which is a Commonwealth case, which defined an act of God as an event or occurrence due to natural causes which occurs independently of human intervention and either could not be foreseen or if foreseen could not be reasonably guarded against. So we believe, and our Mills Oakley view is that COVID-19 does fall under this category, as the virus wasn't man-made, and we weren't anticipating this kind of outbreak. So we do believe it would fall within that category. And the other thing that discussion, which I just read out, brings to light is, if you're entering into a contract now, you can very much anticipate what the effects are of COVID-19, both of its existence and what its effects might be. So what may have been historically in a historical contract give you force majeure rights may very well not give you rights in terms of any renegotiated agreements. So insofar as people are coming back and doing new deals with people and signing things up, it's a new time to just revisit. You won't have the same protections in respect of COVID-19 if you rework your contract with the same wording. The same, if your force majeure provision doesn't just refer to act of God, but refers to other unusual or unforeseeable conditions of the physical environment, those kinds of provisions, again, we believe that they would, COVID-19 would fall within those kinds of provisions as well. So we do believe that most force majeure clauses will come into effect. The relevant then becomes what happens in the event of force majeure. So when you read your contract, often there is a period of suspension, and you need to read your contract to determine whether that just defers the doing of activities, and whether it also means you can defer payment, or whether you still have to pay during those relevant periods of suspension until termination. The other matter is that just because an event happens, if you can still perform the relevant functions under your contract, albeit that it might cost you more money, or that you might need to take alternative routes in terms of how you deliver those products and services, it's unlikely that a force majeure provision would apply. For those people who don't have force majeure provisions, there is a common law concept of frustration. And the common law concept of frustration is where two parties have got together and made a contract, and then the circumstances beyond either of the contractual parties' control, the contract is unable to be given effect to due to outside circumstances. And where that happens and the contract is frustrated, the contract is automatically terminated at that point of frustration. The concept of frustration exists in common law, and it also exists in varying state-based laws as to what happens in respect of deposits that are being paid under frustrated contracts. Can you get refunds in respect of them? What happens in respect of historic works? And there are quite different situations under the common law, and also in Victoria and New South Wales as to what happens in respect of deposits. Under common law with frustration, you would lose your deposit if you'd paid it, but under Victorian law, you would have an ability to claim back your deposits. So thinking carefully about whether frustration might apply, thinking about whether or not you can still comply with your contract, but then thinking about where the losses lie, having regard to common law and also state laws. One relevant factor to COVID-19 is going to be its time frame. There's a relevant case when the SARS virus was out. I won't go out pronouncing the Asian names that are involved in that case, but I can give anyone details as to what they'd like. But there was a lease whereby there was a 10-day period whereby the tenants were denied access. It was alleged that that was a frustrating event, and the court said no, a 10-day event in respect of a 2-year lease was not so significant to the contract to actually frustrate it. So again, thinking about issues such as suspension, termination, whether or not there's an ability to get out of your contract, there are a number of different avenues to look at, and the provisions of your actual agreement are going to be the most relevant. The other things for people to think about at the moment are the ACCC has put out some guidance for businesses as to how to deal with customers who are asking for refunds. And there's some very helpful information on the ACCC website about what happens if you're running an event. Do you have to give refunds? And the answer is no, largely in that context. But if you're a supplier of goods and services and you're unable to supply them, likely you do need to give refunds, etc. So I'd like to direct people to the ACCC's website to get a bit more information that's set out in some helpful examples. Also want to mention competition law. So there's been some views by people that to get through the current crisis, what we would do is look to cooperate with our competitors in a whole range of ways. Cooperation with competitors brings with it competition risk, and competition laws very much continue to apply. So where you are looking to cooperate with your competitors, you need to seek ACCC approval in advance. You can't ask for forgiveness later. They can only give approvals in advance. What the ACCC has indicated, however, is that they will look to support cooperation between competitors insofar as it relates to matters, for example, to do with supply chain, whereas looking to cooperate with each other around pricing related issues are less likely to be approved. Equally, people with market power who are looking to take advantage of the current situation to damage their competitors need to be careful about the relevant provisions that relate to market power. And then what I just want to touch on from a general commercial perspective is the foreign investment provisions. So third, the Foreign Investment Review Board. Typically there are a range of thresholds and a range of categories of businesses and industries to which you require Foreign Investment Board approval before taking on board overseas investment. Those categories have now disappeared, so it's across the board, and the dollar thresholds have gone to zero. So anyone looking to bring on board an overseas financiers or do deals with overseas people to have them invest in your businesses and provide funds, yeah, you should be careful to ensure that you've launched your relevant approvals with beforehand.
Thanks, Warren. That was very, very informative, very helpful overview of some of the current issues, you know, in relation to contracts and so forth. Do you have any comment there just in terms of plant and equipment leases, anything that you might want to say in regards to some of those agreements that you haven't raised already, Warren?
So I think typically, so the issue with your plant and equipment lease is if you are the person who has leased the equipment, you have the equipment, and typically your sole obligation is just to pay. So the fact that there is a COVID situation and you're not able to use the equipment, you're still very much able to pay. So from your side of the transaction, you're likely to still need to pay unless you have negotiated into your contract in the specific provisions by way of force majeure or deferrals, etc.
Right. Okay. Well, thanks, Warren. What we might do now is just kick over to Tony and just get a bit more from you, Tony, just around, you know, directors' responsibilities and maybe anything that you can add around the staff side of things. So over to you, Tony.
Yeah, thanks, Rob. Hi, everyone. Hope everyone's coping okay in these times. As Rob mentioned, I'm going to just talk a little bit about directors. There's been a lot of measures, obviously, introduced by the government to help deal with the crisis. The main one, really, for directors is in relation to a temporary relief from personal liability that results from trading while insolvent. There were quite a number of measures, but that seems to be the main one for directors. Under current laws, you probably all know, directors are personally liable for debts incurred if they're incurred where there were reasonable grounds to suspect the company's insolvent, or incurring the debt would lead to the company being insolvent. Now, obviously, at the moment, there's a lot of financial pressures around for reasons that have been discussed, by Pablo and Warren. Companies are scrambling a bit, and so there need to be some fairly urgent decisions regarding incurring debt. So the temporary safe harbour that's been rushed through is designed to give directors some more confidence to continue to trade and pay their bills and just keep the economy still rolling to the extent they can through the retention of staff through the COVID crisis, without further pressure being applied that they'd have to, in the absence of this relief, have to look at putting the company or the business into administration if there's a chance it was insolvent. So in terms of how it applies, the directors can get relief in relation to debts incurred if the debt is incurred in the ordinary course of the company's business, and there is a 6-month period that applies for this temporary relief. It started after the legislation was introduced on 24 March, so 6 months from the 24th of March. And obviously the government has discretion to extend that or make it a longer period if they want to through regulations. So there's the debt being incurred in the ordinary course of business, incurred during the 6-month period, and it's got to be obviously incurred before an administrator or any liquidator is appointed for it to be able to be applied. Now, obviously, what is actually in the ordinary course of business is a key question. The government hasn't been overly prescriptive in this respect because obviously each business, each company is inherently different. And so it doesn't go into detail on what that would be. So the thinking is that it will be in the ordinary course of business if incurring the debt is necessary to continue the business during that 6-month period on commencement of the law. And some examples of that would be debts incurred to potentially continue to pay employees during the COVID period. Could also include taking out loans to move some business operations to an online sense. So obviously, a lot of normal retail operations are closed down. So and a lot of businesses are moving to online. So any sort of debts incurred in relation to that would be able to be relied upon. In terms of stuff that potentially wouldn't be available to rely on the temporary relief, it's a little unclear as to whether things like debts or loans in relation to some form of recapitalisation of the company would qualify. That's unclear, but it's a matter of degree, I suppose, and you need to take care to assess the debt and whether it's incurred necessary for the business to survive, and that's going to vary for company to company and on a case-by-case basis. Obviously, if there is any sort of doubt, you probably should look at getting some further advice. Now, then you've got to move on to the onus of proof. So if someone decides that we don't think you had that safe harbour, who has the onus of proof? Normally under the insolvency provisions, the proof is on the person trying to make the director liable. under these new rules, given it's in favour of the directors, the director wishing to rely on the relief needs to bear an evidential burden. That doesn't mean they've got to prove beyond a reasonable doubt, but they've got to be able to point to evidence that suggests that there's a reasonable possibility that the matter exists or it doesn't exist. It's good relief for directors. It gets one thing out of the worry to a certain extent for them. Other changes that were brought in were in relation to statutory demands. Now, statutory demands, you're probably all aware, is a means whereby a person owed a debt can issue a claim under the Corps Act and go to court, and if it's not paid, then you can wind the company up. So it's a very big stick for creditors to use against a company, and it can only be used where there isn't a bona fide dispute in relation to the existence of the debt, but nevertheless it's a big stick. So there are also changes to the operation of statutory demands and the limits. So under the preview, and those changes also apply during this 6-month temporary period. So prior to the 6-month period, the threshold to issue a statutory demand was a debt of $2,000. That has been increased to $20,000. So you can't issue a statutory demand unless the amount in question is at least $20,000. They're also under the current or the previous the rules under the Corps Act outside of the 6-month temporary relief period. If there was a statutory demand made, the person owing the debt would have to pay within 21 days for it to get rid of it. That now has been extended to 6 months. So you can still make a statutory demand, but the government's brought in measures whereby it gives a lot more time for companies and businesses to pay it rather than face the consequences of potentially having their business wound up. So there's further relief there. So these reforms, I suppose it's important to note, they're not a free pass as it was for directors. All current director duties still continue to apply, and there's obviously common law and statutory duties, the main one being to act in good faith in the best interest of the company, others including to act with care and diligence, avoid conflicts of interest, and the like. So all the current director duties continue to apply, and it's important to that the debts incurred, they're going to still be payable. So any sort of dishonesty, fraud, or other illegal activity like Phoenix activity where a board decides to sort of put the company into administration and then start it up again, that's going to still be subject to criminal penalties. So it's important to just not take any of these temporary leases as carte blanche, as it were. So if a company is approaching insolvency, it's necessary to exercise careful judgment in deciding whether you need to incur the liabilities when the solvency is questionable, and you also need to take the interests of creditors into account still. Now, if you do fall into a formal insolvency, the temporary relief will be taken not to have been available if it's failed to comply with other obligations and other obligations of assisting the administrator. So it's very important, if you do find yourself in a circumstance where the company or the business does fall into a form of insolvency, that you comply with your obligations to assist and provide records because that is one of the elements of this relief, is that if you don't comply with those obligations, don't assist the administrator, don't provide the books and records that you're supposed to, then the safe harbour relief won't apply. So that's an important consideration. So it's important. You need to take reasonable steps to inform yourselves about, your financial ongoing viability, and just be aware that this is one of the I suppose the tools in the kit bag that you can have up your sleeve in these times. I also wanted to quickly touch on some of the employment matters that might be relevant. So I'll briefly touch on, workplace health and social safety considerations, the impact on wages, standing down, and employee and redundancy. Sorry. As you'd probably all be aware, most organisations have already got a lot of their staff working from home, which is obviously the government's decided to impose for the benefit of everyone. But to the extent that any sort of employees are still at the workplace, and even to the extent they're working from home, it's important for employers to identify and manage the health and safety of their workers still. And that may be by providing information, training, instructions, ensuring that the workplace is kept in an appropriate hygiene, sanitising, and also to the extent they're working at home, making that as suitable as possible by providing appropriate equipment, technology and the like. So, and also reminding your employees that they have duties themselves when they're in the workplace. So to the extent that they own the workplace, there are other workers there, they need to take reasonable care for their own health and safety and hygiene. So there are obligations that go both ways. You may, where they are also working from home, you may want to help them with assessing their workplace, getting photographs, getting them a checklist for self-assessment, things of that nature, to make sure you're complying with your obligations to workers. Now, I understand there was another webinar on standing down and wages and what, so I'll just briefly run through that. But you're probably aware that in terms of annual leave, that is normally governed by wards, but as a general general point, you can only take you can only direct employees to take annual leave where they've got excessive leave accrual, and that's generally considered from our workplace group as determined that's generally where it's more than 8 weeks leave, and the way that you would go about that is trying to reach an agreement with the employee, and if you can't reach an agreement, then give them a direction. And during that, you shouldn't make sure that their leave goes under 6 weeks. You can't really require them to take a period of under 1 week, and you've got to give them reasonable notice to take that leave. And it can't be inconsistent with any other arrangements that you may have come with that employee. In terms of long service leave, this is a changing feast, and the New South Wales government's relaxed long service leave provisions just recently, where they can take long service leave of less than a month. So that's a changing landscape all the time. So people should keep their eye on the press there in terms of the announcements from the government. Then in terms of reducing wages and hours of work, that is best done by way of an agreement. You can't unilaterally just change the wages, but there are, obviously this is happening quite a bit, and the take home is that a lot of employees will more than likely prefer the the result of having a slightly reduced hours and a little bit less pay rather than being made redundant. So that's although you can't unilaterally just cut people's salary wages, those necessary conversations and hard conversations are sometimes a better option than cutting employees totally. And so a lot of organisations are bringing in those results and making those arrangements with their employees.
So that's really helpful, Tony. Just one question that's come through here. If an employee is deemed by an employer to be high risk due to travelling privately, can you exclude them from the workplace? And if so, do you still have to pay them?
You'd still have to pay. I mean, if there's a situation where obviously there's a belief that a reasonable belief that their presence in the workplace would be a danger to other people, then definitely you should direct them to work from home. You need to look at the actual award and enterprise. If there's any enterprise agreement that's relevant, that would be, you need to look at that as well. You can't just unilaterally stop paying people unless they're made redundant, as a general rule. I mean, there's obviously, there may be some specific circumstances, but generally, you can only stand people down without pay if they can't be usefully employed. Under the legislation, you can stand people down without pay if there's industrial action, breakdown of equipment that the employer can't be reasonably held responsible for, or there's a stoppage of work for a cause that the employer can't be reasonably held responsible for. So that's under the Fair Work Act. They're the basis on which you can stand down employees without pay. So you need to look at the award and the enterprise agreement to see whether it's dealt with in there in any detail. But generally, if there's an ability for them to work remotely, if they are sick, obviously, then you can. If they're sick and they don't have accrued sick leave, then that's the case. But if they're saying that they're not sick, then that's a different standpoint.
That's helpful, Tony. I've just got a couple more questions here. I'm mindful of time, but I might just kick back to you, Pablo. There's one question here. Just they've got numerous commercial tenants, and the vast majority of them aren't affected by the shutdowns and so forth, but they all have this perception that they're entitled to relief thanks to ScoMo. Got any kind of suggestions or advice on managing that situation where people have got these expectations that perhaps they're not entitled to?
Yeah, very much so. Look, I said at the start that that's one of the concerns that landlords have because of the messaging, is that the tenants may get the idea that they're entitled to free rein and effectively just a free kick and not have to pay any rent for the next 6 months. That is definitely not the case, and if that is how it's been understood in the broader market, it's not right, and I would caution tenants strongly against taking that view that they can simply just stop paying and they'll be fine. Certainly, while there's been no legislation enacted that helps us in any way, the messaging has been that there will be some kind of hardship test. As to how that looks, I don't know yet, but Scott Morrison's words were that they, A, would have to be severely financially distressed, and B, that financial distress has been as a consequence of the impacts of COVID-19. So To put that in perspective, if you've got a tenant that's been in default for the past 6 months, there's no reasonable argument to suggest that it was COVID-19 that actually caused that financial distress. So in that position, I would suggest that, short of there being new legislation that says something to the contrary, that tenant wouldn't classify against having their lease terminated, because their default under the lease was pre-existing and it had nothing to do with COVID. So no, I think I read I can see the question there myself, but I don't, in terms of how you manage it, I think is the second part of it, is I think you have to have a decent communication set up with your tenants, Matthew. It's what I've seen my clients doing, and I think it's probably the best way to do it is, I think you need to put a communication out there saying, that you that you hold them to their leases and that their leases remain on foot, and that that being said, that you're cognizant of the government's advices and recommendations, and that if they want to apply to you for rental relief, that they will need to satisfy you of certain things, and that for you to consider and ultimately have the ultimate say on at the end of the day. So the questions to ask would be things around along the lines of, show us your P&L for the past 3 years, and so you can make a determination on how their business has been affected, and you'll be able to see, and perhaps it might be a requirement that you get an update monthly as to turnover and so on from their accountant, and you might also ask those questions that I said earlier around how they've been, whether they've consulted with an insurer, do they have business interruption insurance, have they got advice from that insurance as to whether they're going to be covered or not, and basically giving your tenants homework, if I could use that term, giving them homework to come back to you on, to in effect prove to you that that they are suffering financial distress, and then it's up to you to consider that. And at the moment, you are not lawfully obliged to allow that rent relief. It's the ultimate decision actually as to rent relief still currently lies with landlords. The stick, I guess if you could call it that, is that if you choose not to adhere to the principles as they've presently been set out, the risk you might face is that, say for instance, banks won't allow you the flexibility that they're allowing some others. There's the bank's loan deferral scheme, which has been recently updated, but so far there's nothing else from government that is of direct benefit to landlords as such, except for maybe if you're a landlord and you employ several people, in terms of trying to get the government subsidies to pay your employees and so on. Like that is something that you would miss out on if you don't play nicely, as the government's asking you to at the moment. So what they're saying is, if you don't play by our principles, then you just won't be entitled to like any part of the stimulus package that would otherwise be available to you.
Thanks, Pablo. I'm mindful of time, everyone's time. So I just want to publicly thank the team at Mills Oakley, Pablo, Warren and Tony, just for their time today and their expert advice and opinion and so forth. And so if anyone needs to drop off at this stage, you're welcome to. If anyone there has any other topics that they think would be practical and relevant in terms of helping business owners deal with the current environment, please come back to us and let us know. There are a couple more questions. One here from IRFAT, just around the eligibility for government stimulus for a new business. Look, IRFAT, I suggest you look at the Treasury website. That has the most specific information that you'll generally find around some of those stimulus messages, and probably not a complete topic for the legal discussion here today. The only other one here, Pablo, another one for you, is just whether there's any precedent elsewhere say the Christchurch earthquake or anything like that? Any examples from anywhere else of principles that might be helpful?
Yeah, unfortunately, if you're a tenant, it's not that helpful. There was a case on, so Warren touched on the concept of frustration earlier, and frustration was that principle that a party can't actually perform its obligations under a contract, and therefore, or it can, but it would be radically different to that which was contracted for. That there was, so first things first is frustration in its application to leases. The bar is set very, very high in terms of trying to make it out to begin with. So the first things first is it's very, very difficult to make a claim for a successful claim for frustration of a lease, and that is because a lease is considered unique and special, and that what you are getting as a tenant under a lease is an estate in land, which is different to what you get under a general contract. So for instance, a contract to hire goods, you get the entitlement to use the goods, whereas the land, an estate in land is considered special, and therefore trying to make a case for frustration of a lease is very difficult. Now, there is a case out of Hong Kong that is almost directly relatable to present circumstances. There was a case in Hong Kong where a tenant tried to claim frustration of a contract on the basis that SARS, if the last outbreak, SARS had such an effect on its business that it couldn't actually open its doors, and tried to argue that the lease was frustrated on because of it. So that in that case, it was found that no, there was no frustration, and some of the factors were that they still had the right to have their interest in land. They still had the right to an interest in land, and that's the most significant, I guess you could say, of the finding. That is the most significant part. The second part was that the shutdown was for a period, I think it was 2 or 3 weeks, where people weren't allowed to go out, basically. And they're saying that in the context of the wider lease, the lease went for, I can't remember the exact term, but call it 5 years, and a 3-week shutdown in a term of 5 years is neither here nor there, and therefore the claim for frustration had to fail. So unfortunately, the directly relatable case, it's not a precedent in Australia because it's from Hong Kong, but it would certainly carry some influence in Australia, being another Commonwealth nation. And but yeah, unfortunately, the precedent, if we can call it that, isn't helpful to tenants here. Helpful for landlords, not so much for tenants.
Thanks, Pablo. That's actually a very interesting point in terms of that Hong Kong side of things. But thanks again, Tony, Warren, Pablo. Great to have you on the call today, and thanks for thanks for your input and guidance today.
No problem. And our details are on our website. If you go to millsoakley.com.au and you need to look up any of us, you should be able to find us pretty easily if you do have questions that you need answered following this little session.
Great. Thank you. Thanks, guys.
Bye.
See you. Bye.